Speaking of another decision that has slipped under the radar, do we, without expressing any opinions on the matter, because we cannot contest the legitimacy of the elections, Michigan came out with an interesting ruling. We didn't talk about this last week, right?
It came out this week. It was a good ruling because the court made what it is the F word in this context is fortify. And so as Time Magazine said, there are a bunch of rules changes that help fortify the election. And the big constitutional question is, are those rule changes constitutional? The Supreme Court, when they didn't take the case, said it wouldn't change the election. Justice Thomas pointed out it's whether these rules are constitutional is the big question, and we're failing our duties by not taking the case. And they did. But this court didn't fail their duties. The court laid out that what the Michigan Secretary of State did was change the rules in order to fix the outcome in a particular manner, but said didn't think it impacted the actual outcome. I disagree with that aspect, but that's for history at this point.
It's when you bear in mind the amount of absentee ballots that were mailed in Michigan, you can assess the credibility of the statement that it didn't affect any ballots. Exactly. But the bottom line is the court was adjudicating on the question as to whether or not, I forget, Jocelyn Benson had issued guidance, which is how to interpret the law.
And in fact, we discussed this exact guidance, I think prior to the election or soon after the election.
When we were still allowed.
This was that example, remember, where you could sign your name in cursive, and the Secretary of State in Michigan said it might still be maybe a match, if you change to block print. And I mean, anybody could sign. I could sign Viva Fry and block print, because then I don't even need to know your signature. It was a crock.
With that, Robert, that's awful close to an opinion. I'm joking. But what the bottom line is, Jocelyn Benson said in the guidance as to how to interpret signature matches, she said there is a presumption of validity. The court took issue with that because in the law, there is no presumption of validity.
And there sure isn't for nominating petitions in Michigan or anywhere else.
And the judge the case went further, which was presumption of validity. And if there's any, I think it was the word was any matching hallmarks. It was even broader language. If there's anything that allows you to draw the connection, then it should be deemed valid. And the stats are what they are. The record numbers of mail-in in Michigan was 4.8 million mail-in, I think. I don't want to make a mistake. But bottom line, the court said what Jocelyn Benson issued by way of guidance was effectively either modifying the law or creating a rule, which itself had its own procedure under the Administration Procedures Act, the APA. And she effectively created a rule or modified the law without passing through the legislature. Therefore, it was illegal and unlawful. It didn't affect any of the ballots. It was never alleged. So they didn't actually say it didn't. They said it's not alleged that. And
which was
declared illegal.
Because they're not going to get a reversal of the election from Michigan. That ship has sailed. So remove that as an issue so the judge can just focus on the law, not the political immediate past political ramifications of her ruling.
Abraham Lincoln, don't allege not that which need not be alleged, lest you be required to prove that which you cannot prove, or that which you know you will not be able to prove. So they removed that.
Will just antagonize the jurists so they don't make a ruling on the law.
Yeah. So I mean, it's amazing. The one thing though they said is the issue is still ripe. I guess they said the issue is not moot because the guidance is still in effect. My question, tongue in cheek, was what would have been the case and how would the court have ruled had they modified the guidance or adopted that very same unlawful guidance by way of legitimate legislative means? Like, what would the court have said then?
Well, the other thing, if they had handled all these things beforehand differently, then I think that it does in fact impact the election. That ship has sailed, but it's important for going forward because we need to make sure that these rules are passed by the state legislature in a constitutionally conforming manner that includes following the rules of the Administrative Procedures Act, which are about democratic involvement in rulemaking by executive bodies. And they just broke all the rules this time, in my view.
Well, they
decided,
they didn't break the rules. They just changed the rules. This is quoting from the Time article. They just changed the rules in 2020
They effed the rules, which I only mean in terms of 4 to 5, folks. Don't mean in terms of anything else.
Now, signature matching in the recount in Maricopa County.
They're looking at the actual ballots in both Georgia, Fulton County, and in Maricopa County, Arizona. They're getting the opportunity to look at the actual ballots. So in Georgia, it appears it will include a signature match check. In Arizona, it won't. And there, it's only for going forward. In other words, again, doesn't have any impact on the past election, but will impact whether or not these rules were properly whether they were properly created and whether they were properly enforced. Because again, the big constitutional questions about the election going forward for the future elections are only constitutionally qualified voters voting? Are they voting by a constitutionally qualified method? And is the vote being counted and canvassed in a constitutionally consistent, constitutionally conforming manner? And that's what these evidentiary findings by Maricopa County and Fulton County hopefully will help give us some better detail on. And this ruling in Michigan was a great ruling. And they've had similar rulings in Wisconsin, similar rulings in other places where they've basically recognized that the rule changes that took place were not done consistent with state law or the Constitution as it applies in different jurisdictions.
Which one out of Wisconsin?
I forget which one. It was a ruling in Wisconsin, and there might have even been another state where they made a comparable ruling. So there's been more and more jurisdictions recognizing problems with how this election was done and not wanting it to repeat. And there again, the court of public opinion matters. The more people who raise questions about this, the more people who are active at a local level, the more people who are engaged in the legislative process at reviewing things like what's happening in Maricopa and Fulton. They all know when they dig into the detail, they're going to discover things that are problematic. Otherwise, they wouldn't have hit all this. So I think it will be helpful once there's some more and more distance from January 6th and this past election. I think there'll be more honest adjudication, hopefully, about what happened last time so it doesn't repeat.
Right. And if anyone hasn't seen that vlog, I mean, go watch the Michigan decision vlog. It's very interesting stuff. Okay, moving on. What do we go to now?